matter
In case of review, as regards single bench matters passed by whom? When I will sit singly, then you mention it, but not before this bench.
with these minor justice I would
This is a
kindly allow discussion for media report to be come for the execution procedure.
It will be better to mention it when I sit singly. That is the process.
Lordship, may I beg to mention the matter for enlisting the mention, Lordships? Lordships, tribunal matter.
All inclusion give. For inclusion, everybody give.
It's also inclusion, my lord, but the urgency is that, my lord, I am fighting this litigation for 15 years. My lord, I have, this is by this order, my lord, I have claimed retrospective.
Give all in the next one. No precedent to anyone.
My lord, may I have your lordship's leave to mention a matter, my lord? This matter is a matter of second appeal, my lord. This was listed before your lordship before Puja vacation. This matter was heard extensively by your lordship, and this was kept for 4 orders. Now, after change of determination, my lord, your lordship has no more the jurisdiction. That if
Sorry.
your lord,
Now it will appear before the concerned bench. Not tied up, then it is not tied up. Yes.
Lordship, may I permitted to petition for restoration?
Give. Monday. Monday.
My lord, I am the petitioner in person. My case was WPCT 238/2024 was going on in the courtroom number 11. There was an instruction. I was not given a appointment in the Department of Post. So there was an instruction to the respondent to give me the appointment, and then the determination changed and the
So if already there is a direction you mentioned before that bench, why are you here? If a direction has already been issued to give you appointment, then
Right.
there will be, maybe it will involve a proceeding for them, against them for contempt. Then why you have come here?
The respondent said to the honorable judges that they need instruction from the Department of Post.
So there is no direction to appoint.
Acha.
Is
This
there?
this is the instruction.
You are saying there is a direction to appoint, then you are saying that they are seeking instruction. Where does it say? Where is the direction to
The
appoint?
oral instruction, it was the oral instruction
Unnecessary.
to give me the appointment
Yes, it will come in the next month. Take it.
next month.
Appellate side, item number 1. Yes. What is the matter?
I approached the learned state administrative tribunal, but for appointment to the post of particular post, Krishi Projukti Sahayak in the SC category.
Under the SC category.
SC category. Now I'm not on the sole ground that I had got more marks than the last impaneled candidate. Now I'm not, similar issues were decided by the division bench of this honorable court, not directing that whoever gets the person in that case who had got a higher marks, not he was directed to be appointed, since the state administrative tribunal had earlier decided the issue in favor of the applicant in that case. And although the matter was being taken up by the learned member from time to time, including direction for filing reply and rejoinder, but ultimately he decided that unless the division bench would sit, the matter will not be decided, since it involves a substantial question of law.
And there are many other matters arising out of the same recruitment
It has
process.
already been decided. Please come to 2 orders. Not one is at page 55, which was affirmed by the division bench at page 60.
What was the mark scored by you?
And I got 86.25.
And what was the cutoff in SC category?
81.50 was the last person who got appointed.
81.50
50.
and you got
86.50. 86.25. This was available on a RTI reply.
82 points. Sorry,
I got 86.25.
where is that RTI reply?
And that's at page 66. The reply to query number 2.
Was there any qualifying marks for the interview?
No, the last impaneled candidate got.
Lordship, there was a cut-off marks in the interview.
Huh?
There was a cut-off marks in.
No, not cut off. Was there any qualifying marks in interview? No minimum qualifying. Then what is there to do in this matter?
My lord, first of all,
Why he has to come to the court?
my lord, in case of Pritam Ghoshal, what the my learned friend has referred, my lord, that is the problem, the contention of the petitioner that there was a cut-off marks, we impose a cut-off marks prior to the interview, lordship, as the examination started by State Public Staff Selection Commission. Thereafter, in the year 2017, Staff Selection Commission repealed and merged with Public Service Commission. Thereafter, the rest of the examination was conducted by the Public Service Commission and recommendation was done by the Public Service Commission. Prior to taken, written examination was taken by the Staff Selection Commission. The only interview was taken by the Public Service Commission. Prior to the interview, my lord, the Public Service Commission informed by the way of notification in a newspaper that they are imposing cut-off marks by the strength of their full commission decision. Also. In the earlier matter, in the matter of, lordship may remember that in Tamoshi Kona, that the cut-off marks may impose prior to the commencement of the selection process, or the prior to the candidate must know that there is a process to impose cut-off marks. But in that case, the honorable coordinate bench told that the petitioner got the appointment, and in Tamoshi Konar case, the honorable division bench to hold the contradictory decision, lordship. In Pritam Ghoshal and Tamoshi Konar, the point of law is the same, lordship, that we cannot impose cut-off marks or the rule of the game in the midst of the way of the selection process.
That is not their, that is not their grievance. They are saying whatever is your cutoff mark, he has got above that. Why has he been excluded?
We impose cut-off marks in the interview. In interview, he does not reach the cut-off marks.
What is,
That is why.
what is the cutoff marks in that?
In interview, 5 is the cut-off marks, and he got 4 in the interview.
So that is what we were asking. It is not cutoff. It is minimum qualifying. It is not minimum qualifying. It is only cutoff.
It is only cutoff. We use the term cutoff. Cutoff is 5, and he got 4 in interview.
Where is this?
But in their RTI, we have disclosed that he got in interview 4 marks at page 66.
No, where have you said that the interview also there was required to be minimum 5 marks? Every parameter was required. You were required to be successful in each and every parameter.
Then direct for exchange of affidavit, then only disclose the documents for yours.
You did not file the affidavit?
No, my lord, in this no exchange of affidavit was filed.
Before the tribunal, they did not file a reply despite
We
a
have seen what the tribunal has done. There was no scope for anything there when it has declined to hear. But where is the, have you said in your reply to the queries made under RTI that there is a
Page
cutoff.
66, Lordship, can you come to page 66?
The
That-
previous
that's our reply to
29th February 24, the learned tribunal directed exchange of pleadings.
66.
66 is a reply, my lord, given by Public Service Commission.
Same selection process.
It is very clear in the reply that you are relying upon.
Yes.
EC reply to query 2. They give the marks on the 3 parameters. And with respect to cutoff marks for SC candidates, they give the cutoff marks in all the 3 parameters. So
Mark
from,
sheet for individual candidate was not prepared. Query 2, your lordships are referring to.
yes.
I mean,
query
was
2,
not prepared by West Bengal Public Service Commission, so it is not possible to provide requirement to the petitioner. However, marks obtained by the petitioner are 60.25, 14, 4.
correct. So that is the marks you are relying upon. At the very outset, you said you have got 86.24. Now come to query number 4. What is the cutoff mark for SC candidates?
Yes.
Then they give the cutoff marks in all 3 parameters. In the last parameter, the cutoff mark is 5.
Yes, please now come to page 62.
62.
Yes. The same selection process, this honorable court has already decided.
Just, yes.
In your paragraph 8, paragraph 15. Page 63, paragraph 8, 15. Paragraph 8, sorry, I'm sorry, paragraph 8. The qualifying mark in respect of those 3 stages was, however, never prescribed prior to each stage being held. It did not come to the public domain, but it's in respect of the self-same recruitment process. The private respondent was called for the interview, which presupposes that the private respondent qualified in the written examination one and was good to take the interview. The private respondent was disqualified on the basis of marks obtained at the interview. It is the claim of the writ petitioners that the private respondent did not obtain the qualifying mark at the interview. The interview was for an aggregate of 15 marks. The private respondent secured 5 marks therein. The private respondent obtained 79.25 marks in part 1, 13 marks in part 2, and 5 marks at the interview. The aggregate that the private respondent therefore rustled up in the selection process was 97.25. Paragraph 15. In the facts of the present case, the private respondent secured higher marks in aggregate than the last person who was granted an appointment.
Come to paragraph 18.
18. As noted above, the writ petitioners did not prescribe any qualifying marks to the interview prior to the commencement of the interview. Therefore, at 64.
Yes. Please read it. We have just gone through it.
Therefore, it cannot be said that the private respondent participated in the interview knowing fully well the parameters of the interview. Apparently, a cutoff mark was prescribed after conclusion of the interview. This prescription of the cutoff mark subsequent to interview obviously was not communicated to
It is for the same recruitment process.
same recruitment process. And please see page 32.
That findings of the coordinate bench, my lord, is not correct because we have, the interview has taken place in the.
No, if it is not correct, you would have challenged it.
And please see page 32.
Yes, my lord, that is the truth thing that we not assail the.
Then how can you, it's not open to you to argue that this court will take a view otherwise than the division bench. Or you can, how can you as a state judge his claim on a different parameter than when it is already decided and you are bound by the order? You cannot do that. You just have to examine that if his case is.
Prior to the interview, we have published in the public domain. My lord, we have published,
You cannot argue that there is a clear and explicit finding. You are not disputing that it is regarding another recruitment process, regarding the same recruitment process. So you will be entitled to the same relief. We're giving you time Monday. You find out, take instructions, we'll record an order, whether it arises out of the same recruitment process or not. That is all. That council.
I file the affidavit of service. Okay, later.
This is in the earlier case.
This, I don't know 1 month.
Item number 2, may please issue. Madam, for the petitioner, original applicant. I have served and copies are delivered already.
You served and
It is already delivered. This this matter, my lord, pertains to my lord, the incumbent, my lord, who is the widow of the railway servant, my lord, who passed away, my lord, during the service. And my lord, his son, in the meantime, my lord, got the compassionate appointment. Now, my lord, she has been, the petitioner before your lordship, my lord, has been granted extension to possess the quarter, the relevant, my lord, quarter, for a particular time, up to, my lord, 2015. After that, my lord, she made a prayer so that her son could be accommodated in the quarter in which, my lord, she has been residing. And that prayer was rejected by the respondents, railways. And after that, my lord, rejection, I vacated the, my lord, particular premise quarter. And after that, my lord, an office order has been issued by directing the forfeiture of amount of gratuity, my lord, to the tune of 10 lakhs and also 4 lakhs more than that. That means, my lord, 14 lakhs were assessed, 10 lakhs have been deducted from the DCRG, death cum retirement gratuity, and 4 lakhs were directed to be, my lord, given from the dearness relief of the pension. Against that, my lord, I have come before the learned tribunal, and the learned tribunal dismissed my prayer on this score by quoting the impugned order only, which, my lord, says that since I was given the opportunity by saying that so that they gave me the notice so that I quit and vacate, and also they rejected my prayer for staying in that particular quarter. So this they are, my lord, entitled to get the amount deducted from the gratuity, and accordingly, my lord, the original application was dismissed. Against that, my lord, I have come for this one. My lord, yes. But the point which I'd be, my lord, agitating before your lordship only, that whether, my lord, deduction from the gratuity would be admissible straight away, my lord, without initiation of the proceeding of the, my lord, public premises, eviction of the Unauthorized Documents Act 1993, 71, sorry.
public premises?
Yes.
It's railway property.
Yes, my lord.
How that public premises will apply to the railway property?
Because, my lord, the Railway Service Pension Rules provides that.
What?
That public premises Unauthorized Documents Act will be coming into play for the purpose of vacation of that particular railway.
For the purpose of vacation,
Yes.
not
And
for
also, my lord, forfeiture of the amount of
there
gratuity.
is a dispute that you are not entitled to retain in the quarter beyond 211.15.
I do not dispute that.
Then what has to be assessed?
But I tell you, lordship, I
Whether
was
you will
extended,
be liable or not, that is the only issue.
but I was extended up to, my lord, 2015, let us say.
211.15, that is your
Yes,
admitted
yes.
case.
And after that, my lord, I made a prayer to them.
So therefore, merely because the prayer is pending,
And
they are restrained from making any recovery.
my lord, not. But, my lord, they rejected my claim in 2019. And thereafter,
What
my
is
lord,
the date?
Yes.
See, public premises or any proceeding, if there is a dispute, there is no dispute.
My lord,
Yes. What is
I
that
tell
date?
you. Whether, lordship, the dates would be, my husband, my lord, passed away.
No, the date of disposal of your claim for
Claim,
continuing.
my lord, I tell you. My lord, বসো. My lord, I tell you, lordship, my lord, it is page number 54. That will be the clearance certificate, my lord, and which would, my lord, show that I vacated the premise on 20th June of 2019.
No, when did they refuse to allow you to continue?
Yes. The rejection. That your lordship will see, my lord, কোনটা বলতো? 55. My lord, page number 52, if I request your lordship to 52 and 53. I'll take your lordship to that. But at page number 53, if I request your lordship to. '53.
No, this is not earlier. It has already been rejected. Where is the earlier rejection?
But previous, okay, but the lordship sees 52. The son, the letter written to my son. It's 3 days back.
They have filed a
Yes. Reply.
reply.
Yes, ma'am.
This is not your rejection. It has been rejected as per the
But,
order several times earlier.
Page number 74 kindly sees, ma'am. It is the reply of the respondents.
They say that there is earlier rejection also.
But I'll just try to find out and tell you, Lord. Page number 74. Or page number 76, Madam Counsel. Internal page number 3, paragraph B.
Paragraph D.
B for
B.
Bombay.
'24/11/17.
Yes. Then see that I preferred several representations.
No, repeated
Yes.
representations
Yes,
does
yes.
not
Absolutely.
help you.
I'm not on that one. Only, my lord, my prayer, only, my lord, one point, my lord, I'd like to agitate to your lordship, whether the payment of gratuity act, my lord, permits such deduction.
Under the railway rules, there is a provision for withholding of gratuity.
My lord, if I take your lordship to the railway service, my lord, pension rules,
Yes,
my lord, rule 16.
yes. Normally, you are correct. Gratuity cannot be withheld. But in railway, if I remember correctly, there is a provision.
I also, my lord, tried to find out, though that is not discussed. My lord, I only, my lord, took the printout of the relevant pages, your lordship, kindly excuse me.
What is it? What does it say?
My lord, it says that in this particular cases where the the relevant quarter is retained for a particular time, the gratuity could be withheld.
See,
Withheld.
yes.
And it would be, my lord, given back after after someone vacates. Lord, kindly seize the books.
So the purpose of withholding is to
My lord,
assess whether there is any liability.
it does, my lord. Lordship, kindly see that because only one part, my lord, I'll be just taking, your lordship. My point is only that. If your lordship is satisfied, otherwise, my lord, I'll be out.
Yes. Yes, which provision?
My lord, rule 16, my lord, the lordship kindly sees that. I just request your lordship to come, my lord, down to rule 16. If any particular is not possible, director. Say.
This is a master circular.
My lord, that is amended by a master circular, they said. If kindly sees, my lord, 8, 7, and 8. Withhold, I'm sorry, recover. Anything, the rules. ঠিক আছে, ঠিক আছে।
Yes, C is very clear.
Yes, it does. But this has been well dealt with. This is why I just tried to well show your lordship the provision against me. Right. If I request your lordship, my lord, see the payment of gratuity act once. Right. But I do have the copy, my lord. 2 copies I do.
You have to copy.
Yes. Kindly seize, my lord, section 14 once.
Yes, we are,
Your lordship has seen, my lord, 1,000 a time.
we are aware.
But this has been, my lord, discussed, my lord, by the Honorable Supreme Court. Lordship has also seen this judgment, my lord, quite a number of times, my lord. So I will not take your lordship because it has already fallen from your lordship because railway is exceptional. So I'm not taking your lordship to the Supreme Court here.
Yes.
So I'll just take your lordship, my lord, to this Honorable Court, my lord, where this similar situation not came. And only section 14 I was taking your lordship to, and section 4, subsection 6. My lord, if I so from 17, my lord,
Oh, but please show us the Supreme Court judgment also.
yes.
Please show us the Supreme Court judgment.
May I request your lordship to see, my lord, paragraph number 5, which is at page number 594.
This is not in respect of the railway.
Railway, it does not.
Yeah, I have.
But one of the proposition, my lord,
Yes,
talks about,
I remember seeing a judgment in respect of the railways also.
I'll try to, my lord, find out, my lord. I'm sorry, my lord,
It is better to consider that.
I'll do that, my lord. I'll do that, my lord. And lordship has seen, my lord, this honorable court's paragraph number 17, my lord.
You're relying on 4-6.
My lord, yes, 4-6. Read with my section 14 and then section 13.
14 and
13.
And the division bench has considered any Supreme Court judgment.
Yes, ma'am. I just request your lordship, my lord, to see, my lord, paragraph number 15. And my lord, I was also checking, my lord, whether this was appealed before the Honorable Supreme Court. My lord, this was not.
You serve a copy,
I'm sorry.
serve a copy on the.
Other side. Yes, my lord. I've already served. They have received. I've got the affidavit of service.
But who is appearing, you know?
I don't know. I'm sorry.
You have served in the,
I have done that, my lord.
where do you serve it?
My lord, one in the Ministry of Law and Justice, and another, my lord, to the GM Secretariat by hand, and another, my lord, by post to the workshop, Kharagpur, which they have received. My lord, today, my lord, I'll be once again serving to your lordship. My lord, today I'll be just beseeching your lordship for the interim protection, so that this relief, dearness relief, my lord, may not be deducted from the pension.
It
Because
has
this,
still not been done.
I'm sorry.
Only that 4 lakh amount.
Because
Dearness
10 is already deducted.
10 is already deducted. Where is the affidavit of service?
Yes, the affidavit of service, lordship, since I did not, my lord, append this track report because I took it today, and it has been delivered in 9th of November.
All 3.
Yes, my lord. One is by hand. My lord, my learned friend, my lord, says, is it Maniklal Banerjee lordship is referring to of Supreme Court?
I don't have that
Yes,
sharp a
yes.
memory, but I remember seeing it
I'll
may
just
be,
check it out.
may not be, I don't know. You see, if you see, you will realize,
Yes, yes.
you will understand better that.
That's right. Union of India was planning to remain. The element. It was a part of the
So this only says respond number 1 and 2. Does not say about the ministry.
But the railways, my lord, they are, my lord, represented by the general manager's office, my lord, which they have received by hand. Subject to correction.
It may be better. Why don't they have someone authorized in the High Court to make see the matters? What was the date of death of the employee?
I tell you, lordship. My lord, it would be 2nd of November 2013.
Also, 2 years they allow to
Yes.
continue.
They allow.
That is why it is 2/11/2000.
2015. 2 years they have. When, my lord, they will be appearing before your lordship on the next time, my lord, I'll be arguing on this point that whether they can, my lord, straightway say that you quit, I thereafter quit, and thereafter they can straightway take this amount out from the gratuity without even giving any opportunity. Straightway. That it will be deducted, if even if they could have said, that would be meant some differences. But they straightway took the 10 lakh amount out from the gratuity and say 4 lakh will be deducted from the DNS of the pensions, which is at page 58. পাঠালাম তোমাকে জাজমেন্টটা কোন পোর্শনটা পড়বে 2006 ভলিউম কত এটা পাঠিয়ে দিচ্ছি তোমাকে মানিকলাল ব্যানার্জি Date on which he has vacancy. Before 11. না what do we do? After filing this, my lord, we usually serve it on the Ministry of Law and Justice in case if it is not with respect to railways, or even if it is with respect to railways, then we serve the zonal office directly by hand, which we
But
did.
now railways, does it have a separate panel or?
Does
not?
it? It doesn't.
Now it doesn't. It has been done away with few years back.
Yes, that I've heard.
So therefore now it is all under the learned ASG.
But ASU we do not serve, subject to correction, my lord. I can immediately serve by today itself. I can do that.
We are not asking you to serve. You just intimate him so he can
I'll do
see
that.
who is to appear in the matter.
I'll do that.
We have requested the learned counsel for the they will come.
Great.
Item number 3.
Your Lordship, in this matter, I am the petitioner, applicant before the learned tribunal, Your Lordship. The snippets of the fact ballot before going to the merit is that the applicant was inducted in the West Bengal Civil Services in the year 1982, and he has completed 32 years of service and get the superannuation at 1982, 2016. During this course of service, there was an opportunity to
He has spent 32 years.
32 years, during the
Already retired.
already retired, during the pendency of the original application, he attained the superannuation. The issue is this, during the
Yes.
yes, promotion to IAS. There in 2010, there was an opportunity to get inducted into the Indian Administrative Service. 2010, there was an 18 vacancy. He was placed in number 16. So there was a legitimate expectation because the impropriety and the character was impeccable. So there was no adverse remark on that. But despite having the legitimate expectation, he could not get the conferment for the IAS cadre merit. Being agreed with that decision, he filed an application before the Honorable Central Administrative Tribunal, and Tribunal, taking into the allegiance of the statement by the UPSC, has conferred the same. The UPSC committee is the omnipotent, and he has decided. So therefore, it cannot be decided by under the judicial scrutiny. And the parameter ballot which was fixed, the last 5-year ACR. In last 5-year ACR ballot, the all ACR, he got very good in 2005-6, 6-7 very good, 7-8 very good, 8-9 very good, and 9-10 ballot, the average was given by the reporting authority, which was later on changed into good by the reviewing authority. So far the integrity part as well as the ACR was never been a matter of impediment in order to grant the cadre of the Indian Administrative Service ballot. And the entire proceedings is annexed, I have served to all the respondents. The order impugned ballot starts from that.
No, your assessment as average
Yes,
in 2009-10.
yes. And that was subsequently the reviewing authority make it good.
Where is that?
Yes.
This promotion is not actually it's not a promotion in the true sense. It is granting of the benefit of the IAS cadre it's a different kind of a scrutiny. It is not a, it's not a promotion in the true sense that based on inter se merit a right will accrue in favor of any individual that he must be.
No, that is right, Your Lordship is right. But Your Lordship, I have depicted the tabular chart.
Let us see, where is that? Let us see. When you say that average was revised or reviewed and it was made very good, where is this fact in the record?
No, good, not very good. Yes, if Your Lordship will peruse the page 78, this we have obtained in a way of RTI subsequently. And that was a part of pleading before the learned tribunal. And
the scope of review in these matters is limited, either malified or a statutory violation. What is it? Show us.
Yes.
You know this periphery within which you have to.
Yes. That periphery,
it's not a question of assessment of inter se merits that we can review sitting like an appellate authority in these matters.
Yes.
Either malified or a statutory violation.
So far as the malified I cannot.
That you have not. So there is nobody else. Nobody has been arraigned as a respondent.
Yes. My specific issue that at page 18, Your Lordship will peruse. 18, page 18. The specific issue is made if I have satisfy all the levels and ingredient
That is what we are saying, that is not open to judicial review. That is the law is well settled in this regard. There are only two parameters, either a violation of the statutory provisions or malafide.
But
If you must have seen the judgments in this regard.
malafide, I cannot plead mallet because I cannot make my case in that fashion. But the statutory mallet, I can.
What, let us see what is wrong with this, what has not been followed, what statutory procedure has not.
Mallet, they need to follow. Kindly come to the reply of the UPSC mallet. What
See,
they have,
the scope is so limited because there is a basic thing which is taken into consideration by all the judgments. Your grading and your assessment is by the state government.
yes,
And the central government or the UPSC is now going to
yes, mallet.
select you,
Select you. Very good.
not promote you.
Yes.
So
Now,
this selection, they say, it has, you cannot claim a right just because the state
No.
government has assessed you in a particular way.
yes, mallet. Because
So it has been limited to two grounds, either malafide or a statutory violation.
kindly come to page 88 here also. Because in
Page 18 of
page 18 of my writ petition, mallet. 88.
88.
88. 88. Here the table has been given. Only two persons who have been declared unfit from 1 to 18. There is a reason in page serial number 9. The serial number 9 declared unfit due to pendency of the disciplinary proceedings. But in my case, mallet, standing at page number 16, there is no revelation of any fact.
We don't find anything about pendency of proceeding.
Yes, they kindly come to page 83, your lordship.
Even if it is there,
But
that
at
will
least,
not
mallet,
make any
a
difference.
person who is crucified, mallet, at least there's some reason known to him.
It's not a penalty. Don't use the word crucified. It's
But-
not a penalty.
Because
It's not a punishment.
because mallet, so far as the
It is, failing in a selection is not crucifixion.
no, my
Penalty may be termed as a crucifixion.
mallet, if I have not been gone into that particular
Alright,
zone,
let us see page
yes.
83.
kindly come 83, your lordship.
Yes.
83, the revelation that the selection committee has therefore met today to prepare the select list of 2010 against the vacancy that arose during the year 2010. As intimated by the government of West Bengal, the selection committee were informed that the disciplinary proceedings are pending against Sri such and such Chakrabarti. No criminal proceedings are pending against any of the officers in zone of consideration. Integrity certificate has been withdrawn in respect of Sri Chakrabarti. The following penalty has been imposed against the eligible officer, that is naming him, and ultimately remarks by the state government order dated such and such, penalty of reduction of 3 annual increment till retirement have been imposed to such and such. No increment will be allowed during the period of such reduction, mallet. Now, thereafter, mallet, adverse remarks of ACR of the eligible officers are pending expunction of the state government, and there are no court directive having bearing on the preparation of the list. The selection committee were informed that promotion to the IAS are by the provisions of the IAS appointment by the promotion regulation, the relevant provisions of the regulation 5.4 and 5B read as under. Now, the selection committee shall classify the eligible officer as outstanding. Why not open the page? Outstanding, very good, good and unfit, as the case may be, on an overall assessment of their service records. The list shall be prepared by including the required number of names from amongst the officers finally classified as outstanding. then from amongst those similarly classified as very good, and thereafter from amongst the similarly classified as good, and other of the names inter se, with each category shall be in order of their seniority in the state civil services. Provided that the name of the officer so included in the list shall be treated as provisional if the state government withholds the integrity certificate valid. In respect of such an officer, or any proceedings, departmental or criminal, are pending against him, or anything adverse against him, which render him unsuitable for appointment to the service, has come to the notice of state government. The committee were informed that in accordance with the regulation 5.4 of the promotion regulation, the selection committee has to classify the eligible officer as outstanding, very good, good, or unfit, as the case may be, as an overall relative assessment of their records for ACR dossier as made available by the state government. The selection committee would go through the service records of each of the eligible officers with special reference to the performance of the officer during the last 5 proceedings, which the select list is prepared and after deliberation will record to the committee. Then, my lord, this particular paragraph, the committee were further informed that overall assessment of the officer cannot be withheld because of the non-availability of the ACR. The selection committee has to make the categorization on the basis of the available minutes. Thus, where one or more ACR of an officer have not been written, my lord, this is not relevant. And only thing, last line, the ACR for the last 5 proceedings here is relevant. Then after the committee were further informed that the selection committee has to go through the records of eligible officer and make their assessment after deliberating the quality of the officer as indicated in the various column recorded by the reporting reviewing officer accepting authority in the ACR
When
for
did you
different.
retire?
My lord,
When did you retire?
2016, your lordship.
So this rejection is of 2011.
2000, yes,
Then
2000, but it was not known to me. It came into my knowledge because at that point of time, I was not acquainted with the fact my rejection has been required by.
how can you say that there
I'm
must
telling
have been a selection?
Because I
Some
filed this
people-
application in 2016, my lord.
Oh, so you are waiting to retire to raise this issue?
No, during the course
Yes,
of my
where is
employment.
that application?
Oh,
This is a
yes. This OA is a part of your annexure also. That is start from Adj 30.
It doesn't mean anything. You may seek a RTI at any time, but that will not be the date of knowledge.
I got this particular RTI information, my lord, in year 2015.
That will not be the date of knowledge, sir. Have you said that the selection recruitment process was not finally concluded, no result was published, nobody was selected? Why didn't you know? How can you say you didn't know? You can't say that. Can't say that.
I'm taking a remedy which hospital. Yes, but the entire cloud cleared after getting the RTI.
What doubt? You stained out for 6 years, then you want to clear the doubt and then you want to assert a right. Is that a permissible
Check what
under the
applicant-
Administrative Tribunals Act?
what the applicants stated in their petition, my lord, and alternative asked remedy. Yes, sir. That is stated in the OA mallet. Roman 8 VII. That is the only pleading, my lord, that I have made. That your applicant, finding no other alternative, duly approached the respondent by making an application under the provisions of the RTI 2005 on August 14, 2015, thereby seeking some information as to how overall relative assessment of his performance has been arrived at, or to let him know on what basis the relative overall assessment has been made. And by making such application, the applicant wanted to know the concerned circular or any particular provision prescribing the procedure or independently calculating the relative overall assessment on the basis of the service record. The copy of the said application under RTI Act dated 14/8/2015 is annexed here to March next year, such and such. That meanwhile, the concerned Assistant Secretary to the Government of West Bengal wrote a letter to dated 30th March 2015 under reference such and such, thereby informing that the applicant is due to retire on subordination on 30th September 2016, as the date of birth is 4 September 2009. And by that letter, the applicant was requested to submit his formal application for pension in the applicant prescribed form to his pension sanctioning authority, who is the head of the office. Copy of the said letter, ballot. So, ballot, the entire cause of action germinates from the date when I came to know that what the gradings has been offered to me. I'm very candid on my submission, ballot. This is the best thing which I have pleaded. The three tabular chart which I have submitted, ballot, if your lordship will go by the page 17 of my writ petition, I have categorically make the provision of the basis under which I should be considered and what is my criteria. Page 17, Mallet, there is one tabular chart, and then the second tabular chart, Mallet, is also at page 17 and 18, Mallet. These two are my specific pleadings pertaining to my denial of my.
Yes, we are seeing page 17 and 18.
Page 17 and 18.
What is it?
This is, Mallet, the first.
Your self-serving assessment cannot be made the basis of anything. It's a self-serving assessment. It cannot be
I am
made
also
the basis of
taking the plea of the doctrine of legitimate expectation.
Oh, yes, that's very good. Let us see.
I'll try to revise my case on that first.
You know what is the position.
But the only this, Mallet.
In fact, we are at least speaking for myself, I'm surprised how the tribunal has proceeded to adjudicate on merits. The grossly barred by delay. In a promotion matter, 4 years is more than enough. I can give you judgment of the Supreme Court.
Yes.
If you don't choose to agitate your claim within 4 years,
That claim becomes stale, that I know, Mallet.
it's a stale claim.
But the only point is, Mallet, once I will be acquainted with the fact, Mallet, then I can improvise
Once you
my
find out why you have not been selected, that is your case. Not that you did not know. You knew you were not selected. But why you were not selected, you were waiting whether I should ask or not. When you were retiring or at the verge of retirement or after retirement, say, let us ask why they didn't. Then you ask, why didn't you do it? And then you. And after that also, you wait for another, how many years? About 8 years.
during the pendency of this application, it was filed in 2016, you also.
The OA was filed in 16.
16.
So at that time. So immediately on retirement. So that is a gross case of delay and laches.
I am asking to myself, if the revelation pertaining to the unfit to the serial number 9 has been well established that these are the reasons, so at least when they are declaring the unfit to my position standing at serial number 16, so does it not implied upon the respondent to at least reveal the fact that the person who has not been considered under these grounds?
2000.
And the second point, Malik, which is all, it was taken by the authority, the good, better, or best, there is a comparative superlative degrees are there. They are saying the persons are more eligible or less eligible. This is not the mandate of the IS appointment. So therefore, they are more eligible, more suitable. This my
For an appellate forum over the selection committee that will re-inquire and see what was good, what was bad. That you are not alleging malafide against anyone. Which statutory provision has been violated? You can say many things, but those things will not be, they are not liable to be considered.
yes,
The scope of judicial review, you are aware, is very limited.
limited. The highest promotion to quotation. No, what is the statute? I am guided by the regulation of IS appointment and promotion regulation 1955.
Yes, so which statute has been violated? Show us which provision,
Valid.
which rule.
I'm praying for your lordship, this book is not available with me. Kindly,
Where have you stated in the writ petition which rule has been violated? Which ground you have taken regarding violation of which rule?
that is as para 11, your lordship. Your petitioner also obtained copy of the minutes of the meeting of the selection committee, and accordingly, the petitioner came to know that promotion to the IS are governed by the provisions of IS appointment by promotion, regulation 1955, and the relevant provision enumerated in para 5.4 and 5.5 mentioned as under. The select committee shall classify the eligible officers as outstanding, very good, good, and unfit, as the case may be, on overall cumulative assessment of their service record. 6.5. The list shall be prepared by including the required numbers of names from amongst the officers finally classified outstanding, then from amongst those similarly classified as good, and the order of the names inter se within each category shall be the order of their seniority in the state civil services, provided that the name of an officer so included in the list shall be treated as provisional if the state government withhold the integrity certificate in respect of such an officer, or any proceedings departmental or criminal are pending against him, or anything adverse against him which renders him unsuitable for appointment to the service has come to the notice of the state government. Your petition state that the said minutes of the meeting, it was recorded that the committee was formed that in accordance with the regulation 5.4 of the promotion regulation, the selection committee has classified the eligible officer as such and such.
You are for the
Then my para 13.
yes.
Para 13. Your petition state that in the said minutes of the meeting also revealed that the committee were further informed that as the overall assessment of the officer cannot be withheld because of the non-availability to the ACR, the selection committee has to make a categorization on the basis of the available ACR. Thus, where one or more ACR of an officer have not been written for a year or more on account of his being on leave, training, or such and such, no officer supervises work for more than 3 months or any other valid reason during the relevant period, the selection committee should consider the ACR. Then under 14, that the said minutes of the meeting of the selection committee also recorded, the committee were further informed the selection committee has to go through the records of the eligible officer.
Again, we are saying we are not scrutinizing what the committee has done. We are not inclined to enter into that arena, and we can consider that.
Then I'm putting my case in a very parochial and a narrow zone, Malik. That under what provisions of the IS promotion and appointment has been violated, Kindly allow me some time so that I can take the book and I will, these are the pleadings, my lord, which I have taken.
Third Land Counsel for the petitioner.
My lord.
Item number 4.
Yes. Lordship, the one liner, my lord. The petitioner retired on 31st August 2013. He has been granted provisional pension. Other than provisional pension, nothing has been paid to him, so far as pensionary benefits are concerned. And that is due to, as per their admissions, respondents' admission, that 3 criminal proceedings are pending against him. And all the pending proceedings are sub judice, and even not yet charges have been put. And there is no question of conviction also. And those are all, my lord, not in discharge of public duties, not in discharge of his official duties in office, in public office. And for that, my lord,
So you approached for grant of final pension.
final pension as well as, my lord, my gratuity has been remains unpaid.
All
Leave
right, so
salary
all
has been-
retiral dues.
All the pensionary
All
benefits are-
retiral dues. Then what happened?
Honorable, I approached before honorable tribunal. Tribunal dismissed it on extraneous ground.
There is no departmental proceeding.
Departmental proceeding was closed, my lord. At
You did
at
not
page
tell
85.
us you are saying only 3 criminal proceedings.
Departmental proceed. No.
First
That-
give us the full fact. So 3 criminal proceedings, even charge sheet not filed. That is your submission.
No, lordship. Departmental proceeding was closed at the bottom and at the
Regarding 3 criminal proceedings, you submit that even charge sheet has not been submitted.
in the criminal code, my lord. Charge sheet has
Correct,
been
correct.
submitted. Charges have not been framed.
Charge is not framed. All right.
Charges have not been framed.
And regarding how many criminal departmental proceedings?
Departmental proceeding, page 85, my lord.
How many?
Only one.
One.
Under rule 16. That is under rule 16. Minor penalty proceeding. It was closed. Page 85.
When it was closed?
It was closed on 4th July 2022.
4th July 2002. What
2022, my lord.
Closed means what? Some punishment was awarded or you were exonerated?
Nothing, my lord. Closed. Departmental proceeding was
Where is
closed.
that order?
Page 85, my lord. Concluding para is, my lord, at para 7.
Where does it say closed? Show us the word closed. He has said closed at least 3-4 times. We are asking him to show the word closed.
Decides to close the inquiry. Last line, my.
Yes. That's all.
In terms, I am reading, my lord.
Please.
I am reading.
You
I am
are
reading.
here to lead us, not mislead us.
No, my lord.
So tell us the
Yeah.
correct thing. Yes.
In terms of para 3 of DOPD's OM,
Yes.
number dated 1/8/2007, if the charge in the criminal case is of grave nature, which involves complicated questions of law and fact, it would be desirable to stay the departmental proceedings till the conclusion of the criminal case. Sri B.K. Bandyopadhyay, inquiry officer, has also been retired, and the act of Sri Deepak Das, senior accountant, has not caused financial loss to the employer. The competent authority hereby decides to close the inquiry into the charges framed against Sri Deepak Das, senior accountant, and further action will be decided according to the outcome of the
Outcome of the criminal
Course.
proceeding. Yes. It is conditional order. It is not closed. Now it
My
will
lord,
be decided after the criminal proceeding. Yes. Then what happened?
I approached before the honorable tribunal.
Yes.
I on the stressing on that it has been decided law, my lord. Those not in discharge of the official duties in public office, pensionary benefits cannot be withheld. That order has also been passed by the honorable tribunal in case of the co-accused. Relying on the Supreme Court judgment, my lord, honorable apex court judgment, and honorable Delhi High Court.
Where have you said in your OA that these criminal proceedings are not in relation to your discharge of your duty? Show us in the OA. Where have you made this statement? These three criminal proceedings are under which sections?
In various sections, my lord.
Which show us? Let us see.
In the charge sheet, my lord, at page 63.
Page
63. Departmental charge sheet, in Article 1, sections have been quoted at page 64.
you are working in?
PO revenue, that is under the chief controller of accounts.
All right. So these are sections, but these are sections which say public money. You have misappropriate public money. You are also working in an office which deals with public money. Where have you stated in the OA that the charges in the criminal proceeding are not relating to your discharge of official duty? Show us from the OA. That is your specific case. That is your basic argument that you have made. Let us see.
In the grounds of appeal,
Show us from your OA. You are saying the tribunal has failed to consider that the three criminal proceedings were not in relation to discharge of official duty. How the tribunal can consider only if you have made out that case. We are asking you to show from the OA that you have stated before the tribunal that none of these three criminal proceedings were arising out of any allegations relating to discharge of your duties or your office.
department stand is very clear, my lord. In the
No,
charge
we
sheet,
have to see your stand. Department stand will come after your stand.
I have relied upon the
Please show
tribunal.
us the statement. You have made a specific statement here in court that this is the case which the tribunal did not consider.
Page, my lord, page PO. What are the criminal proceedings pending? I have made page
Where
45
have you
to
said that the criminal proceeding are not in relation to your office or discharge of your duties? Show us that one line. Where have you said in the OA? It's just a one line you have to show us. That is your whole case. That is your whole
R.
basis of your whole argument. Let us see which
OA, para 4R at page
4R
45.
at page.
Page 45.
Yes. We are asking you to show why. We don't find this statement. You're not able to show any such a statement before the tribunal. That's not your case, which you are arguing.
Not in my lord. From para R to S, page 46 also I have mentioned. What was the case? In my
Where
co-accused case,
have you said that it is not in relation to your office or
the
discharge of the
applicant has neither been convicted in any criminal proceeding nor implicated in any other proceeding pending finalization, where allegations of grave misconduct in discharge of official duties are there,
not
whereas
not convicted? Does not mean it is not
where
convicted.
allegations of grave misconduct in discharge
Yes.
of official duties are there.
Correct.
Whereas
You have not been convicted. That does not mean that the charge is not in relation. You have not been convicted. That is not in dispute. Conviction and
whatever I have made that.
Conviction and accusation are two different things.
Let me read, my lord. Let me read. The applicant states that ratio of the decision of the Honorable Tribunal in way number 1801 of 2015 in case of applicants co-accused in Sakrail Police Station is squarely applicable, since, alike Sri Acharya, the applicant has neither been convicted in any criminal proceeding nor implicated in any other proceeding in discharge of official duties are there, whereas departmental proceeding vide memorandum dated 31st March 2014 issued under Rule 16 of CCA Rules 1965 stood closed, and admittedly, as evident from competent authorities' findings in its letter dated 047/2022, there was no loss to the government exchequer, and for that matter, nothing is recoverable from the applicant. And for that matter, instead of provisional pension, regular pension is admissible to the applicant hearing, and gratuity,
Yes,
salary,
yes.
CTIS,
Yes.
so withheld.
Yes, in paragraph S you have said. What is your reply? Where is your reply to this paragraph S? No, where is your reply to paragraph S? You must have filed WS. WS must be on record.
Page 140, my lord.
This is 4S.
4S.
This is 4S. TCS pension rules. The CCS pension rules.
Yes, my lord. Which rule, my lord?
CCS pension rules.
My lord, provisional pension is under Rule 69 1B. মামলাটা কঠিন আছে। মামলাটা কঠিন। মামলাটা কঠিন আছে। করতে পারছে না। The current rule is also there with me, my lord. Recast. Rule 69. এখানে অ্যানেক্স করা আছে। Yes, my lord. 100%, but gratuity has not been paid. Leave salary, my lord, no loss to the exchequer. In the closure order also, no loss to the employer. So leave salary can't be withheld. Because as per rule 39(3) of the leave rules, leave salary can be withheld if anything is recoverable from the government servant. Otherwise, and gratuity also, my lord. That is the rider, my lord. It is not that the simple withdrawal or simple closure with a rider. There is no loss to the government exchequer.
Yes.
And it also, another corollary comes out, my lord, that those are not in connection with official duties. In discharge of duties in public office, that Supreme Court has stressed on it.
What about the other criminal? All three criminal proceedings are arising out of your loan.
Loan, my lord, with there is dispute between the promoter, bank and flat owners. 55, my lord, at Panchayat. 55% have been arrested.
Promoter, bank, and
No, flat purchasers.
oh,
He was flat purchaser.
loanies. All
Yes,
loanies.
loan.
So what is why you have yes? What do you want to say? No, what is your case? We'll see. The tribunal's order is not that is before us. We will see. Where have you said that it is the proceeding is in relation to his official duty? In your reply, there is no such averment. You have not denied the statement made in 4S. Come to page 140. Paragraph 26. You are not denying this. You are saying something else. It means nothing. 69 1B. What 69 1B? Yes. Paragraph. This is not relating to the criminal allegation. Why are you?
That OM is that, my lord.
By the additional district that 9-2 of Alipu, that is one of the cases order and about 1,00,000. From the detailed gratuity of the applicant and that the three people, the applicant that currently ongoing guarded counsel for respondents and submitted to the applicant was charged serious offenses which are punishable and
The court has directed. What are you reading? From where are you reading? Which page?
it's not there. Yes, here. Tribunal's order started from
No, no, we will not see the tribunal's order. We want to see what is your case. What have you said? Tribunal's order we are not going to look at right now. We are trying to understand. We don't know where is that from your show from your WS 1,50,000.
That is there, my lord.
Interested in the tribunal's order will come later.
and regulations.
No, no, 69 1BB and C both we have seen. That you are not required to show us. The issue is very small. You are not addressing the issue. The issue is whether it can be done when the proceeding is not really in relation to a official discharge of duty. What is your stand on that? Unnecessarily 69 1B and C will not do anything. Then
Departmental proceedings only pay for some type of deciding the criminal issue.
that we have already seen. That you know we have already seen. So that is a repetition. But that is a repetition which is not required. We are again asking you the same question. If the proceeding before the criminal court is not in relation to his duty or his office, can you rely on 69 1B? That is the only issue. Let us see what you have said.
But the provision there is gratuity other things. According to the departmental proceedings.
Again you are saying the departmental proceeding we have already seen. Don't that departmental, that is your order which says that no financial loss is involved. So therefore that cannot be relied upon. If the criminal proceeding is in relation to his official discharge of duties or arising out of his office allegations in relation to his office, then it may be different. Otherwise, we'll see what we are just trying to understand. What is your case?
For the instruction of the department.
What instruction? Everything is here. Instruction. Now let us see the tribunal. Oh, there is a speaking order 29/3/19.
Yes, my lord.
Where is that? That will contain everything.
Speaking order on, my lord, on applicability of rule 54, paper 54B. FR 54B, where the suspension period, what will be the date of the suspension period? That is at page 76, my lord. Page
29,
75,
319.
76.
29, 319.
2939.
Page?
Page 75, 76, my lord. That is the repetition of earlier order. Page 75. Page 75. At relevant para is, my lord, para 9. So it is earlier to closure order.
Surmises, conjectures.
What is the allegation in 159 of 2011? Sankrail PS case 159 of 2011.
Lordship, in charge sheet at page 63, what is the department, what alleged is there? At page
63.
Page 63. That is article of charge. 63 and 64. 63 article 1 is the single article 1, and there is no annexer also. No RED, no witness.
We are asking you what is the allegation in Sankrail PS case number 159 of 2011.
That is the charge, my lord. What I can that the said Sri Deepak, I am reading out, my lord. The simple, small portion is there that the said Sri Deepak, the senior accountant under suspension, while functioning as senior accountant during the period from 27/11/2012 till 3/12/2012, had been arrested by Kolkata police on criminal charges registered under section 409, 417, 418, 420, 467, 477A, 120, 120B, 34E of IPC in the Sankrail PS case, banks public money to the tune of 15632,000. In the said FIR, the names of 21 persons were shown, and Sri Deepak Das was one of them, mentioned at serial number 15. Hence, on receipt of an intimation of his arrest by CID, West Bengal, cheating and fraud section, Bhavani Bhavan, Kolkata, he was placed under suspension under deemed suspension in terms of sub rule 2 of rule 10 of CCA rules 1965. Right,
Sir,
under
you
reference
are,
such
you are the accused in the case.
Hmm.
Charge sheet has been submitted. You were arrested. We are asking you what was the case about. Why can't you tell us? The other two cases, one is regarding an insolvency matter. The third case is also it is regarding a personal loan. Only one case we are not able to find out. What is it? Tell us. You are the accused. You
No.
were taken into custody. You don't know.
I was taken into the custody
What is the
by
allegation?
by the police. I was released on bail on
What is the allegation?
allegations that come out from the CID arrested, and the charge, since charge has not been framed, that is
What
in
was the
connivance with
allegation? We are asking you. We are not asking you who arrested you, whether charge has been framed. We are asking you what is the allegation.
Lordship.
Take-
In the
think we have
certified
to ask
copy
you
of in the certified copy also,
What certified copy? You have the FIR.
159 by 2011.
You have the FIR.
At page 59, my lord. It starts at page 59. This is also
Yes, show us the judgment you are relying upon.
para 11. It will- Para 11, my lord. State of Jharkhand versus Jitendra Kumar Srivastava, my lord. Para 11 is a relevant para.
This will not apply. This is for 43B of the pension rules, state pension
That is
rules.
perimeter to
It is
CCS
not.
pension rules, my lord.
It is not.
Honorable
69,
Delhi High Court judgment, my lord.
69 1B is totally different from 43B. I know the provision 43B. It is not
My lord,
that we don't know.
Honorable Delhi High Court's order. In
You have
in
any
Asaki.
judgment on 61, 69B? You have any judgment on 69B?
That is, my lord, that is Rule 9. Rule 9 only. Rule 9 of the CCS pension rules 1972. That calls for that only gratuity pensionary benefits can be cut or withheld by the order of the Honorable President of India.
Sir, we are asking you, they have referred to a specific provision 69 1B and C. On that, you have any judgment? 43B will not apply here.
43B of that is perimeter to Rule 9, my
It
lord.
is not.
Honor,
43B we have seen. It is the same provision which has been taken out of the Bihar pension rules. It has been applied to Jharkhand. We, at least one of us, is familiar with that section. 69 1B is totally different. 69 1B.
that is, my lord. I am only stressing on that point that government servant, he has done, that is not in discharge of the public duties.
Correct.
As government servant.
That
It is
is
in course of his business. In
43B is not on this aspect.
Lordship may like to,
43B is that
Lordship
unless
may
there
like
is
to peruse also Honorable Delhi High Court judgment.
43B is on the point that unless he is held to be liable under order passed by the court or proceeding, it cannot be withheld. That is 43B, and that is 43B applies to after his retirement.
Yeah.
Yes, show us that. What are you showing? That you have any judgment on 69B or C?
See, there are four, my lord, opinions judgment, Honorable Delhi High Court on withholding of the pensionary benefits. Para 4 is there, my lord.
This will not apply. Both of these judgments will not apply. We are asking you, we have seen the facts. We are just waiting for you to show the judgment. If you have not come with a judgment, then what can be done?
That is what these judgments, the law comes out that one pensionary benefits can be withheld only in case of person if he is otherwise engaged in official duties, in discharge of his official duties. That is the because
This is all. You are
where
not
from, my
relying,
lord, recovery can be made.
so you are
from
not
him.
relying upon anything else. Then we'll
Under Rule 69 1B as such, I am not. But since nothing is recoverable from him, so pensionary benefits like gratuity, leave salary can't be withheld.
Your submission, if we have understood correctly, is that because there is no departmental proceeding. In the departmental proceeding, they have already said there is no loss to the government money. In the criminal trial, you say it is not in discharge of official duty. Therefore, there is no basis to withhold. They are saying under Rule 69B, they have the power to withhold if there is pending criminal proceeding. Whether this criminal proceeding under the rule means any criminal proceeding or criminal proceeding in relation to the duty, this you have submitted. Now you are relying on judgment which is for something else.
I am relying on the judgment on the question of law that has been settled by the Honorable Supreme Court
That is
in discharge of duties in public office.
Where is
I am stressing on.
Where is it so?
That is in para 11, my lord, or Honorable Supreme Court.
43B is a different provision, sir. Why don't you understand what we are saying?
I am stressing on that connotation, my lord, that in discharge of public duties.
That is a different provision. Rule 9 and 43B have been They are invoking power under Rule 69. They are invoking power under Rule 69, not under Rule 9. They have withheld, they are saying that we have withheld in exercise of power under 69. So you have to show us a judgment with relation to Rule 69.
Rule 69 1B, my lord, comes later after only when after retirement, when gratuity and pension is withheld, that can be made only by order of the president under Rule 9.
But this is after retirement. Your case is also after retirement.
He is already retired, my lord.
Therefore, 16, they are referring to 69. Which paragraph of this judgment you are relying?
Para 11, my lord. That the employee had committed grave misconduct in the discharge of his duty while in his office.
This is regarding departmental proceeding. You are not trying to appreciate what we are saying. This is regarding a departmental proceeding. They say they are invoking power under 69 because criminal proceeding is pending.
They are also, my lord, criminal proceeding was there under PC Act.
In paragraph 11 of this judgment that you are reading, it is referring to Rule 43B. Have you seen Rule 43B? Is it quoted here in this rule? That is a different provision. 43B is, I have seen it so many times. It is the
Not
same
that I
provision.
know.
It
That I
is the
know.
same. It is the same provision. After bifurcation of the state, verbatim the same provision has been applied to the state of Jharkhand.
My lord, this judgment is based on DS Nakara judgment, where the pension is a property. DS Nakara judgment has been, pension is a property. It can't be withheld without going to the procedure under constitution provisions of Article 300A. He has earned it. That is the question of law, my lord. DS Nakara, since then it has been also followed, my lord. Even Honorable Rajasthan High Court also. My আমি জানি কি বলছে, না জেনে কি আর বলছি না, নাই ওরকম ভাবে হয় না, রুলের উপরে এই যে কোনোটেশনটা, এই কোনোটেশনটার উপরে কিছু নেই। Rule 9, my lord. Rule 9 is perimeter to Rule 43. Lordship,
Judgment, has it been quoted in the judgment that you are relying upon?
yes, my lord.
Where, which page?
Yes, Nakara judgment has been reproduced. Para 7, my lord.
Pension is not a bounty, is not relevant. What we are looking for is that if it is not in discharge of official duty, where is that?
Honorable Supreme Court has held on that in para 8. What is his observation?
Regarding
Is
the
the hard-earned benefit of which accrues to an employee and is in the nature of property.
we are not asking you that. We are asking you where is that paragraph from DS Nakara which has been, whether it has been quoted that even if it is a criminal proceeding in discharge of, not in discharge of duty, then it cannot be done. Where is that?
It has flown from the what is the observation of the Honorable Supreme Court in the Srivastav case. I am not telling that specifically that word there, but in para 11 of the judgment, it has been made.
In para 11, it is referring to 43B. Why are you not understanding the court's query? You are referring to DS Nakara, here you have not come with the judgment. You are repeatedly showing us pension is not a bounty. That who is saying pension is a bounty? Neither they are saying nor we are saying. That is nobody's case that pension is a bounty or it is not a bounty. The issue is that whether Rule 69B can be invoked if the allegation is not in relation to the duties. That is the only issue. That has been dealt with in DS Nakara case. Where is that paragraph we are asking?
No, DS Nagara as such on the nature of the pension, what is characteristics of the pension has been defined.
Where is the judgment?
It's a
Without judgment, you are making submissions. We are asking you for such a law.
So Rule 69(1)(b). That is my candid submission, my lord.
All right. So then whether if an allegation which is not in relation to discharge of duty, that can be made the basis of withholding pension or not. This has been considered in DS Nakara.
No, my lord. That is not that.
Then why are you not coming with judgment on this point? We are asking you repeatedly. You are showing us pension is not a bounty. 43B parameteria with section 9, rule 9. All
that has been held by the Honorable Delhi High Court in para 4 or OP Nasa case. That I have shown before the lordship. OP Nasa case in para 4.
Para? You are relying upon a single judge judgment before the division bench.
69(1)(b) as such.
You are relying upon single judge judgment before division bench.
No,
You
no,
are relying upon single judge judgment before the
that has
division
been
bench.
relied upon. Also, my lord, Honorable Rajasthan High Court also. It is also single bench judgment. In para 14, my lord.
No, come with the proper judgment. Otherwise, we are not going to. It is for you to make work out this. We are not going to search for you. We are asking you a simple question, you are not giving the answer. You are relying on all provisions which are irrelevant to your case. You are relying upon all provisions which are irrelevant to your case. We find that you have a case, otherwise we would not have waited so long. We are waiting,
my
you
lord.
are still not able to show any judgment. What can we do?
Exclusively Rule 69(1)(b).
You have to come with 69(1)(b). You have to come. That is the rule which has been invoked. You cannot rely on 9 and 43(b). You cannot.
That has been relied
If you
upon
want to remain, if you want to confine to this, then all right, we'll consider these judgments. We are telling very, very clearly they don't apply to your case. If you want, we can consider.
Let me search. My lord,
You are unnecessarily wasting time. We have been
No,
asking you
my lord,
repeated.
it is my understanding of the law that Honorable
Come with
Supreme
the
Court,
judgment.
Honorable Supreme Court, what he said
List
that
after 1 week.
in discharge of the public duty, that has been
List
followed by
after
the
1 week.
various courts, my lord.
We come after 1 week. Come with a specific judgment on this point.
Rule
Not
69(1)(b).
No, not 69(1)(b). Where does it say that the purport of the rule is that it has to be in discharge of official duty? These judgments will not help you.
Not highly pass a necessary order, just.
All right. For further consideration. Find 69.
That we
You want it for a 2 week.
After 1 week.
Gotcha. Search করে দেখি। Item number 5.
One 1398, you joined in the BOPT.
My lord,
1398.
My lord, 98, 88, my lord.
88.
Yes, my lord.
And the OM is of
First May
1587.
1987. my lord.
87.
Yes.
Nearly 1 year before.
Yes.
Just yes.
My lord, initially, my lord, if your lordship can allow me to start the fresh, my lord. Initially, my lord, I have joined the Great Eastern Hotel, that is the government of West Bengal undertaking, my lord. And where, my lord, I took the benefit of, my lord, CPA because that benefit was not there. After,
Yes. So at the time you were working in the Great Eastern Hotel, that was also West Bengal government undertaking.
yes, my lord. And when, my lord, I have joined in this BOPT, my lord, straight away, my lord, I transferred my employees' provident fund to the account of the BOPT, my lord. Thereafter, my lord, this office memorandum in the form of the lordship, the 4th Central Pay Commission came, and they recommended that all the CPA beneficiaries should come over to the GPF scheme.
Where is that OM? Let us see.
My lord, I will. My lord, page 76 of my paper book, my lord. But my lord, I want to place this because it is at all not legible, my lord. So my lord, another. আমি আলাদা করে দিন। May I read, my lord?
Just this BOPT is under which ministry?
My lord, the Ministry of Education.
What is the post? Full form of BOPT?
My lord, the Board of Practical Training, BOPT.
Now it has become under the higher education, Ministry of Higher Education.
Yes, Ministry of Higher
Earlier it was
Education.
Minister of HRT.
HRT.
So whether
Is that
this
autonomous or-
office memorandum, whether you can avail the benefit of this office memorandum or not, that is the only issue.
My lord, my only issues, my lord, since from my joining, my lord, I requested them kindly allow me to exercise my option so that I can take the benefit of GPF scheme. But my lord, they
Under this OM.
under this OM, my lord, and even lordship, even before this OM, lord, even after my joining, my lord, I requested them for allow me to convert for such conversion. Initially, my lord, they said,
How this applies to you? Come to 1587 office memorandum.
my lord, two.
This office, how does it apply to you? Why should it apply to you?
My lord,
Yes.
My lord, as per this office memorandum, it has been mentioned those persons who are ready to conversions, they are
Which persons? Any person?
no, my lord, for those persons who are in the service.
In
Those-
which service? In which service?
In the central
Anybody
government.
in the-
In the central government. my lord.
Correct. So were you in central government service
My
on
lord,
1186?
That's why, my lord, the Honorable Supreme Court declared this office memorandum is clearly violation of Article 14, because this office memorandum is clearly cleared the disparity between the pensioners, between the certain employees.
Certain employees of the central government,
My lord,
not
if you-
central
if you-
government and
if you-
state government.
Supreme Court, my lord.
So from the Supreme Court judgment.
Yes, my lord.
Which-
On the last occasion, my lord, I
Yes.
mentioned.
You have given us a copy of that judgment.
My lord, that has been already annexed in this paper book, my lord.
By which page?
My lord, page 286 of my paper book, my lord. 286, my lord.
Yes.
My lord, on the basis of this judgment, my lord, I praying for the. But before that, my lord, if your lordship for a moment, lordship, kindly set aside this judgment, lordship. Even the director in their resolutions, my lord, in their minutes of the meeting, they admitted, lordship, even they approved my case and they said my case is stand valid, my lord. If your lordship kindly allow me to place that documents, lordship, first. My lord, page 84 of my paper book, my lord, volume 1, my lord.
Page
Page 84 of my paper book.
84.
Your kind attention is invited that it is noticed from the office record and subsequently representations received from Sri S.P. Ghosh, Administrative cum Accounts Officer, that he has joined in this office on 1st March 1988 through proper channel from Great Eastern Hotel, a Government of West Bengal undertaking, where he was a member of CPF cum gratuity. Under the above circumstances, Sri S.P. Ghosh has made representations to this office for giving service benefit of GPF cum pension gratuity instead of CPF cum gratuity, according to the office memorandum number such and such, 1st May 1987. His latest representation is enclosed for your kind perusal. Well, this letter has been later mentioned.
You said it has been allowed.
No, my lord, I am coming, my lord.
Yes.
My lord, this letter has been received by the letter written by director to the Ministry of Human Resource. That time, my lord, that is under the HRD. The Standing Finance Committee in its 36th meeting held on 3rd November 2006 as its board office, that resolution was adopted in item number 36.7 under miscellaneous subhead and subsequently ratified by the Board of Governors in its 99th meeting held on 3rd November 2006 as follows. After that, my lord, the subject matter, well, next page, my lord, the subject matter was discussed in depth and noted that Sri S.P. Ghosh has joined in this office as Administrative cum Accounts Officer on 1st March 1988 through proper channel from the Government of West Bengal undertaking, namely Great Eastern Hotel, Kolkata, where he was the member of CPF cum gratuity. So he was not allowed to exercise any option for getting benefits of GPF cum pension gratuity in this office. After considering the fact, it was decided detailed representation in this regard would be forwarded to the ministry for consideration and approval accordingly. My lordship, next page.
Not allowed yet.
No, my lord, I am not saying, my lord, this approval.
Sir, it has already been allowed. It is not allowed.
But in the
They have decided they will forward it for
for
consideration.
approval, my lord, for
Yes,
approval.
for consideration and approval, not approval.
For considerations and approval. My lord, the next page, my lord, that is the calculation sheet. Has been, my lord,
It's nothing that nobody is disputing that calculation. Yes.
no, my lord, my lord, because of this, my lord, my lord, the next page, my lord.
Yes. And you have moved the authorities when for the grant of this benefit?
My lord.
When have you moved the authorities for grant of this benefit?
My lord, in the year 1988, 4th March 1988.
You joined on
1st March
1st
1988. 3 days, my lord.
And where is the final rejection of this claim?
My lord, there are several rejections, my lord. And my lord, if you logically come to page 92.
Where are the rejections?
My lord, all these my lord, they on that moment, my lord, they never said directly no, my lord. They only sat tight over this my all the representations. Thereafter, my lord, I filed the writ petitions, my lord.
Yes.
My lord, kindly allow me, my lord, page 92, my lord.
Yes, so after writ petition said you go to CAT, then you went to CAT. Then
Yes, but before that, my lord, kindly allow me, my lord, kindly allow me, my lord, page. My lord, kindly come to page 101, my lord.
What is it?
My lord, that letter was my lord, the director wrote this letter to the section officer, Ministry of Human Resource Development in the year 2014, my lord.
He is repeatedly recommending your case. That is what you are trying to say.
No, my lord, if your lordship kindly come to page
He
100.
is not the competent authority to grant this. It has to be considered by the ministry.
Yes, my lord.
He is
My lord, he
repeatedly
himself, my lord, this director himself joined in this service in the year 1990.
maybe what
Now he is availing the benefits of my lord, GPF scheme.
yes.
But I have joined in the service in the year 1988, but they rejected my claim. They said because you have already exercised the option.
Yes.
And thereafter said this office memorandum.
You have already exercised your option.
Yes, my lord, this is the mentioned in their.
They are asking you to show the rejection. You are not showing.
My lord, initially, my lord. Initially, after that, my lord, they said they forwarding my letter. And then they issued the recent order, my lord, where they said.
Where is the recent order?
My lord, the recent order, my lord, page 146.
Yes.
My lord, 146, my lord.
Hmm.
As clarified by the ministry-wide letter dated such and such 27/22, that as per the OM dated 1st May 1987, that last date for exercise of option for changeover from CPF to pension scheme was 30th September 1987. And that
we have read this.
yes. Well, thereafter, my lord, I filed a writ petition challenging this recent order, my lord.
You file writ petition.
Yes, my lord. Because, my lord, initially.
First you file writ and then they were directed to dispose
My
of
lord,
the representation.
my lord.
And then again you filed a writ, then you were relegated to the CAT.
My lord.
And then after availing the CAT, you have come. Yes.
My lord, even lordship, I also filed a review petition before. Thereafter, my lord, these review petitions as well as this order of the court below, my lord.
Why review, for what purpose?
Because, my lord, not a single submissions has been recorded. Even, my lord, as per the order of the court, my lord, I filed the written notes along with all the judgments, which I relied upon, my lord. But not a single judgment or
What is the earlier order passed by the tribunal?
Earlier order, my lord, that order has been annexed, my lord. Only the impugned order that has been annexed.
Only the review order.
Only the review order as well as the order under review, my lord, that has been all.
So where is that? That is what we are asking.
My lord, that is my
Order
lord, that
under
is
review.
page, my lord, the order, impugned order, my lord.
Order under review. Where is that order? Which
My
is
lord, 336, my lord, page 336.
and the review is at 342.
My lord, review is, my lord, the 416
Page 416.
of my paper book, my lord.
And what is 342?
My lord, 342.
Yes.
My lord, that is the, my lord, the fact, my lord. Initially, my lord, the two order has been passed. 336, my lord. Several anomalies, my lord, in this, the order of the learned court below, my lord. 336.
It is the same order you have.
Yes, my lord, kindly, my lord, I am coming, my lord, I am coming. My lord, in this order, my lord, if your lordship kindly come the next page, my lord, 337.
Yes.
My lord, the applicant name has been different. And the respondent's name, my lord, I don't know whether the respondent is there, but my lord, my name is not be there. My lord, I was the same counsel, my lord, appeared before the London Central Administrative Tribunal. Even, my lord, the date of the order is mentioned 28th September 2023.
Yes.
My lord, on that date, my lord, even I will annex the cause list, my lord. On that date, my lord, there was no pronouncement order had been mentioned in the cause list, my lord. That is also been annexed in this paper book, my lord. That is also been annexed. But the next, my lord, same judgment. They rectified, my lord, when I applied for the certified copy of that order, my lord, they rectified it. Even, my lord,
So this page 336 is not certified for.
no, my lord. Because, lordship, because of this disparate, lordship, I placed this judgment before your lordship.
Certified copy is at 342.
340.
So what is 336 then? From where did
Well,
you get?
because lordship, I mentioned because this date of order, when the date of order is mentioned, there was no bench in the Central Administrative Tribunal. When the date of the order, that moment, my lord, the bench was in the circuit bench, Port Blair. And if your lordship kindly allow me to peruse this order again, if my lord will found not a.
Because it was not heard on that day, it was heard on 19/7.
Yes, my lord, the pronouncement of the order
Yes.
has been mentioned is the date of the order. My lord, on that date, my lord, the no pronouncement of the order has been mentioned in this cause list. But I annex the cause list also, my lord.
Yes. Where did you get this order? The first order, which is not certified. How did you get this order?
My lord, in the server copy, my lord.
No, it is not a server copy. It is not a server copy because it has the signature of the presiding officer.
Yes, my lord.
It cannot be. No,
My lord, that has been, my lord, I obtained this from the server copy, my lord.
cannot be. No signature is uploaded on the server.
Maybe, my lord, then I applied for this copy, my lord.
No, this
Maybe,
is,
my lord, I applied for this copy, my lord. Because of this anomaly, my lord, I again applied for the certified copy. Because the date, because of this date, suddenly I came to know.
Thank you.
No, no,
How could you get a copy of this file where the signature of the presiding officer is there? Very peculiar.
my lord, my lord, as per the order of the court, my lord, I filed the written notes. That has been annexed.
We are not on that. That will come later. How do you get this order from the tribunal? How can you do it?
My lord, from the,
This is a very serious thing.
my lord, obtained a certified copy, my lord.
Not a certified copy. 336. We are very surprised. How you have got a copy of this order which is not
My
certified?
lord, I got from the website, my lord. Otherwise,
It cannot be. Have you said in the OA that you have got this from the website?
yes, my lord, I mentioned in the review petition.
You have mentioned.
Yes, my lord.
Let us see.
My lord, can you allow me, my lord?
Our signed copy is never uploaded on the website.
My lord, that is the difficulties, my lord, from a very beginning, my lord, because suddenly I came to know the order has been uploaded in the website.
Signed was uploaded.
Yes, my lord. After that, my lord, I obtained for the copy. Suddenly, my lord, I take it from my client told me that order has already been uploaded. My lord, how? Because the cause list.
Let us see. What have you said? What have you said? We'll see. Let us see.
Your lordship,
Yes, 146, we have seen the order,
My lord.
the reason order. Anything else?
My lord, for the review order, my lord, if your lordship allow.
Which one?
The review order, my lord, the review.
Yes.
My lord, 416.
You have challenged only the review order.
No, my lord, the impugned order, my lord, that has been mentioned, lordship, page 336, my lord.
That and as well as the review.
My lord, the review, lordship, the main contention of the review, lordship, they neither considered my any submissions, nor they considered my any judgment that I filed before the learned Central Administrative Tribunal, though as per their order, my lord, I filed the written notes of argument. Not a single submission, lordship, has been recorded in the order impugned, my lord.
No, your submissions are noted from paragraph 2 onwards.
No, my lord. Several submissions are there, my lord. Not a single submission, my lord. That has been recorded only from the record, my lord. My submissions has not been mentioned. Several, lordship, they're not a,
From the OA.
my lord, from the way. And my lord, as per their directions, my lord, we filed written notes of argument. Because on the basis of the Honorable Supreme Court's judgment, my lord, the learned Central Administrative Tribunal already followed the footsteps of this Honorable Supreme Court. That judgment has already been annexed.
So we are considering everything.
My lord, only my lord, only my last submissions, my lord, page 140, if your lordship kindly come, page
140.
148, my lord. My lord, on the my lord,
Yes, yes.
my lord, on the basis of the honorable
Yes.
my lord, on the basis of the Honorable Supreme Court's judgment, my lord, if your lordship kindly see the Assistant Registrar of the University College of Medical Science, directed them, my lord, to file their documents so that whether they are willing to submit their exercise to convert from CPF to GPF, my lord. This is with regard to the above referred letter on the above cited subject, the employees both in service, stroke, retired, placed under the CPF who were in the college falling under the category 1 or category 2 are requested to submit the following document duly filed in along with the supportive documents for further appropriate actions in the manner. Option from such and such. And thereafter, my lord, in page 1.
The only distinction which you are perhaps you are missing or you are not deliberately missing, we don't know. All these officers that you are relying, they were already being extended the benefits of the central government scheme. Even this university, by a specific order issued by their visiting chancellor or whatever they call the president, he had extended the benefit of the scheme. There is no such extension of scheme to the government of West Bengal. There is no such extension, but that basic thing is missing.
In this specific paragraph, Lordship, I am relying upon view the Honorable Supreme Court's judgment, where mentioned that two persons joined after this.
Joined what?
Joined the service.
No.
Well, that has been mentioned, my lord. That has been categorically mentioned. Joined after the service, my lord. Where after means, my lord, the prospective effect.
Does not. The judgment is regarding Delhi University of professors. They were getting the central pay. On 1/5, this has come. Just 3 days thereafter, the president has issued that the same thing will be applicable to them. There is no such application of those of that OM in the state of West Bengal. Therefore, there is a vast distinction between you and these persons with whose case you are relying.
My lord, the persons, my lord, where in this particular judgment, my lord, they never mentioned they are after means whether they in the previous, whether they in the central government or the state government.
They are all. It is in the judgment. If you want to read, you can read.
Yes, my lord.
If you don't want to
my
read,
lord, my humble submissions, my lord, the
it is in the judgment.
joined the service in 1990.
It is in the judgment. It is in the judgment that you are relying upon.
Yes, my lord.
They were getting the central scale already.
Yes, my lord.
You were not getting central scale.
No, my lord.
There is a vast distinction. How
my
is
lord, the director himself, my lord, they joined in the year 1990.
Forget about him.
My lord, the director denied me. My lord, if that be so, my lord, director himself joined in the service in 1990.
You have implemented him as a party.
No, my lord, the respondent number 4 is there, my lord.
Whatever he has done, we cannot look into that.
My
We cannot look into that.
My lord,
Whether he has done, whether he has not
on
done.
the basis of this judgment, my lord, the Central Administrative Tribunal principal bench already, my lord, allowed them the retired persons, my lord.
Yes, why not?
The
Those
retired
who are in the central government service on 1/1/86, already in service on 1/1/86 and continuing till the date of issuance.
My understanding, my lord, after 1/1/1986, after 1/1/86, well, that has been categorically mentioned. This after does not give
Correct.
retrospective.
Between 1/1/86 to 1/1/85, 1/1/15/87. That is the period.
Yes,
in this entire period, you were not in the central government.
No,
that is the admitted case.
Yes.
So therefore, you cannot claim parity with
lord,
someone.
these office memorandum.
Therefore, you cannot claim parity with someone who was already in central government service or extended the central government pay.
My lord, this central government, my lord, because this after, my lord, this after will, my lord, will after give me that benefit, my lord. I am come on that because that has been like after, then which notification, which memorandum will applicable to me, my lord. If any persons joined after office memorandum 1st May 1987, the how will be treated?
They will be treated as they were.
As a central government employee, my lord, then I am automatically covered by the GPF scheme, my lord.
That is your submission. We have understood.
Because, my lord, my humble submissions is, if I have been joined after 1980, because this office memorandum, the intention of this office memorandum, those persons are not ready to opt for the CPF or GPF, they categorically mentioned whether I am...
No. The purpose of the office memorandum is that in the benefit of the employees, everyone is deemed to have converted into GPF.
Yes, unless...
Just those who want to continue in CPF, they may do so.
Yes, madam.
It is not that you have an option to do this and that. If you don't exercise the option, you will go in GPF.
Yes.
If you exercise the option, then only you will remain in CPF.
CPF. My lord, in that case, my lord...
That's not for you. That's not for you. You are not an employee of the central
My
government.
lord,
How
if
can
my
you
lord,
be
if my lord, any person joined in the service of any central government employee after 1987, how will be treated, my lord?
Why not CPF? They're still continuing with CPF.
My lord,
Even after the issuance of the OM, there is an option of people to retain or continue in CPF. Because your CPF balance is already there, must be there since before. You can continue with that. Nobody is stopping.
my lord, I have joined in the service after this notification in the year.
We all know that by now.
Yes, yes. After my lord, in the year 1988. So in my case, my lord, they automatically give me that benefit of GPF, my lord.
That is your submission. Yes, yes. Let us see.
I appreciate your lordship. So for these judgments as cited by Lord and Friend, the reliance has been placed that is in his favor. I beg to differ with my Lord and Friend. Well, if we go by the factual matrix of these judgments, only one para 3b, it is quite distinguishable fact that this judgment is squarely applicable only for the employees who are central government.
Oh, that is all right. But look
Yes,
at
that what is fallen from your lordship. My lord, I appreciate your lordship. That is the sentence. It begins with para 3b. On 6/6/1985, the central government employees who were governed by the contributory provident fund, in short CPF.
Yes.
So who were the central government employees?
Correct.
They can opt for switchover from CPF to CPF.
We are asking you a different thing. Since the scheme is conversion into GPF by virtue of a deeming clause in the office memorandum, then why do you resist the claim of such persons who have come later? What is the rationale? We are unable to understand. Your whole scheme of 1587 is that from now onwards, everybody will be GPF. If you want to be an exception, you give an application. That is the tenor of the OM.
But
Now, having come forward with such a policy decision, why are you resisting the claim of someone who wants to fall in that within that deeming category and not opt to stay in CPF? What is the rationale? We are just trying to understand.
my humble
That one stand, we understand that the cutoff date is fixed. That is all right. That we have seen. But why should you resist the claim of someone when you yourself have taken a policy decision? That we are
So,
trying to.
in response to this, my humble submission, firstly, this is a policy decision framed by the central government. We are one of the autonomous body under the central government. Board of Practical Training. My client is point number 4 and
But Union of India is a party here.
Union of India is representing.
Who is appearing for?
And my London friends are there appearing for Union.
Yes, the question is to you. Why are you not allowing the benefit of this policy to anyone who has come after the cutoff date? How many people will come after that? And
Except of that, your memo, it will be applied for actually for all. But here, my lord, petitioner was not an employee in the lordship and something of that. That is why, my lord, this policy, which was taken by the government of the should not be applicable to all the central government employees.
then how you have extended it to the director?
Grateful to your lordship.
How the benefit has been given to the director?
But I'm director. Director is not giving this case. And there is no challenge that in these proceedings.
No, there is one thing. If she wants to challenge, she will implead him. But if she claims parity, she need not implead him.
But director is not getting these things because director, then I am to take instructions.
You have said in your application that.
No, no, my lord.
Then why do you
My lord,
don't make such submissions?
my lord, the respondent number 4 is
No,
the
no.
party, my lord.
No.
My lord,
If you have made a case that it has been granted to the director in pleading,
it's not under
then otherwise we are not.
my lord, because lord, I came from my client's instruction, my lord.
No.
My lord, kindly allow me, my lord. Kindly allow me, my lord. Because my lord, I know
Not allow you to say something which is not on record.
my that is not on the record, my lord. But my lord, kindly allow them, my lord. Kindly give them on the through affidavit that they did not allow them. They did not allow them. If there's any policy against this society.
You continue.
So far, these new points are absolutely beyond the scope of the pleadings before the.
Then we'll not look into. We'll not look into. Yes.
So, my humble submission is only the point for consideration before lordship. The applicability of the central government notification dated 1st May 1987. So at the head note of this notifications, it begins with the word changeover of the employees from contribution provident fund scheme to pension scheme. The central government employees who were in service as on the date of publication of these notifications, they are only governed under and covered also. So not the persons like the petitioner who was once upon a time when it was the employee of the state government.
And when did he retire?
But
Well,
he
2010, after that, my lord, continuing 2000 up to
retired in
2014.
2010, but he, for the first time, he has made an approach before this honorable court by filing a writ petition in 2020, long after 10 years.
No, my lord.
That point.
But
I
that
had
several
raised to
applications
this
have been
honorable
made, my lord.
court, long
Several
after 10 years.
What is this? You are arguing side by side. You want us to listen to anything
Never,
or what is
objected
this?
to my lord.
He was listening patiently when you were arguing. Please take your seat. Yes.
The first, the allegations he brought against my client, my lord, before this honorable court by filing a writ petition only in 2020. But he retired in 2010. For the first time, so for the record says, my lord, he brought it to the knowledge or notice of this our authority in 2005. He had joined in these organizations board of practical training in with effect from 1st March 1988.
Yes.
But so for our record shows, we have received a complaint from the petitioner only in 2005.
Yes, we have seen that is your specific stand in
Yes.
Yes.
So during that period, neither he raised this point nor he opted for. So therefore, the claim is firstly time barred and absolutely delay, but it's a time barred. Secondly, the entitlement. He is not, at my humble submission, is not at all entitled. So far, this notification is concerned. These notifications and the judgment is as relied by Malan Alfred is absolutely non-applicable. So no manner of application in this case, as I have shown your lordship in the paragraph 3b of these judgments, the Soshi Kirans, only for central government employees. So, this is one of the so for the in my understanding, the judgments delivered by the tribunal, which is ordered imputed before lordship today, it stands valid. But kindly, I have very short submissions.
Paragraph 3b.
3b of these judgments. Now, Soshi Kiran. Page 242. Only 3 lines. No need to go beyond the 3 lines. Only first 3 lines, para 3b, the factual score. The on so and so 6685, the central government employees. You can pause here.
That is not the relevant.
And after that,
For this case, that is not the relevant circular.
and
The
paragraph
relevant
25 also.
the relevant circular is at 244 and 245. That is the Government of India circular.
Yes.
Thereafter, it was extended on 5/5 to the university. That circular is at 244,
Yes,
245.
244.
The one you are reading is the one applicable to central government employees.
And 244, subpara C,
Correct.
I also rely on D.
Yes.
Both the paragraphs are not covered. Those who are
The main is 245.
244.
At the top, you see sub para 5 of the
Para 5 years.
scheme which has
Pensionary
been.
benefit to temporary employees. Temporary employees who retire on superannuation.
No, the one at the top of the page. As and when.
As and when the central government amends rules, giving more benefit to its employees relating to GPF, contributing CPF, pensionary gratuity, etc., which are advantageous to the employees of the university. The employees of the university will be entitled to the same
benefit.
Same benefit.
So that was extended to the Delhi University, and thereafter in para 5 below that, they have fixed the cutoff date of 25/5/87.
Yes.
Instead of 1/5, in the case of general central government,
30th September.
it has been 25/5/87. And the cutoff date is no, thereafter the cutoff date was extended several times.
Yes, I'm coming to that.
Up to 87 or 88.
30th September 1987.
Yes, every time they were extending that. If anybody else wants to opt.
After receiving so many
What happened is in the initial phase, most of them opted for the CPF.
Those who are left over, then again.
Yes, then after that they started reverting to GPF. Then the government said, now we will not allow. Then they went to the.
So these are the points and review the reasons given by the tribunal, learned tribunal, why the review applications is not maintainable. There are no such grounds where the review stands. Accordingly, my humble submission, the petitions must fail.
Yes. Yes, anything in reply?
My lord, regarding this policy, my lord, if they said the policy, my lord, if any policy is create any disparity among the employees, my lord, that policy is required to be set aside, my lord. And my lord, another thing, my lord, if you lordship kindly come to page 166
So
of
before 2010, before 2020, you have not filed any writ petition or
no, well, not filed in, but I made a plethora of representation. No,
that is not the
liquidation.
query. We are
No, my lord.
asking you before 2020,
no.
you have not approached any forum.
No.
Yes.
My lord, if you lordship kindly come to page 166.
Yes.
Another office memorandum is come, my lord, if your lordship. Volume 1, my lord.
Yes, 166.
Another office memorandum, my lord.
Yes, what about it?
My lord, this is coverage under Central Civil Service pension rules in place of national pension system of those central government employees who were recruited against the post vacancies advertised notified for recruitment on or before 22nd December 2003.
This, why are you referring to this?
My lord, this notification is
This is much after you have retired.
yes, my lord. That has been after my retirement. My lord.
All,
But this office memorandum is also there, my lord.
yes. This is nothing.
This is my humble submissions, my lord. Only, my lordship, this notification, this office memorandum, well, after 1987, any person joined that will be treated, they have given the options of GPF, my lord. This is my humble submission.
Get it right. Come.
date of retirement দিয়ে দিই।
My lord, the only one thing, my lord, if your lordship kindly allow me, they mentioned there is a disputed. My lord, the director himself admitted, my lord,
Yes.
my lord, the director himself admitted that I have made a representations on 1st March 1988. My lord, that has been admitted in the, that has been already been annexed in this petition, my lord. Only if your lordship kindly this thing.
We have seen that.
I'm
2005 is before 2005. There is no dated representation.
my lord, that has been mentioned, my lord. If your lordship- In the fact sheet, my lord.
Before 2005, there is no dated representation.
And no official signature and seal was.
Correct. That is what we are saying. But that is a disputed position. We are not saying that he is correct or you are correct. We have said that you have filed your representation while you were in service. That we have said.
My lord,
Yes.
only this is the
Now,
direct-
next case.
My lord, my lord, my lord.
Next case. Let it come. Let us see. If I'm not here, it will go up. After 2 days. No, it should come on this. No, date has to be given. Date has to be given. Date has to be given after 2 weeks. Give the date. Let it come. We'll see if I'm not here. Date has to be given.
Item number 6.
Your Lordship, item number 6 to 9, I am appearing for the private respondents herein. Your Lordship, only difficulty is, Your Lordship, I have been unable to file the affidavit in opposition. Your Lordship will kindly grant me a week's extension to file the affidavit in opposition, Your
I'm for
Lordship.
the petition. Waiting. This matter was taken up by your lordship in the last week. This is matter relates to, my lord, that the criminal disciplinary proceeding was quashed on the ground of acquittal of the persons, my lord, the petitioners in a criminal proceeding. You have already taken 2 adjournments, July, August.
Lordship, I
Still in
understand.
November, you are taking an adjournment.
Your Lordship, the
Pay some cost. We'll
Your
give you
Lordship,
an
the
adjournment.
petitioners are suspended employees, Your Lordship.
We are only asking you why so many months have been insufficient to file an affidavit in
Your Lordship, the
opposition.
affidavit is ready, the petitioners
You
will.
pay some costs,
Your Lordship,
whatever.
Your Lordship will kindly
Can't be
not,
like this for the asking. We'll not
Your
allow.
Lordship will kindly.
Will
they are-
not
they are
allow this,
suspended
sorry.
Employees, Your Lordship. Your Lordship, they are not even, to be very candid, Your Lordship, they are not even
This is not
in a position to, Your Lordship, they are in a very difficult position, Your Lordship. Your Lordship will kindly grant us, they are coming on Monday to sign the affidavits, Your Lordship. The affidavits are ready, Your Lordship, any day next week, Your Lordship. Your Lordship, a humble request, Your Lordship. They are in a difficult situation. They have been suspended since years, Your Lordship, now.
the six to nine.
Malad, item 6 to 9, Malad, identical matters.
All matters.
My learned friend is appearing in all matters.
Yes.
Item number 10.
Right. Sit with me if you require. Thank you. Whenever you. None appears for the
Item number 11.
Lordship, in item number 11, I appear on behalf of the petitioner, my lord. I am being led by my senior. My lord, he is suffering from fever, my lord. Kindly takes the matter on Monday, my lord.
you have filed the opposition,
Yes, yes.
already filed.
Yes, lord. Yes, lord.
All parties are served, your lordship, except on behalf of respondent number 6, Mr. Basu, from Mr. Basu, for bearing. Oh, okay.
Did you eat it?
Ask it for it. Yes. No.
We are informed by learned counsel for the petitioner.
On behalf of the 8, in response to the AG Bengal 4 and 5, I have served them, Lordship. And Lordship, I have also filed one CAN applications.
It's already there.
Yes, I filed yesterday. I have served them, Lordship. The CAN app.
Is can 1.
Yes, yes. Not yet listed, probably. Yes, yes.
It's not here.
It Lordship, it is not yet been listed, probably. I have filed yesterday, Lordship. It will listed and it can be hard to get, Lordship.
What is it for?
Is it for, Lordship? The matter was before the tribunal is the entire retirement benefits, not only for the family pensions, also for the GPF, for the leave salary, and for the gratuity. Lordship, thereafter, what happened, Lordship? Justice Tapabroto Chakraborty's bench before, on the first hearing, Lordship, there was a direction upon the petitioner to file a supplementary affidavit and to show that what are the exactly amount what they have received. Already they have received 22 lakhs, not yet received the death gratuity. What I am on, Lordship, that late 50% of the death gratuity, GPF and leave salary be disbursed in favor of minor, as there is no dispute regarding those. There is only dispute in the family pension. And the counsel who appeared for the petitioner, I have annexed the order before Justice Chakraborty's bench. That was, they have no issue with the other retirement benefits. They have only issues related to the family pensions.
All right. You want to file something today?
Not sure, I've handed over the affidavit.
At the top, make a note, affidavit on reply is taken on record. Yes, next.
Lordship, written it Monday, it will be there.
Yes, you said Monday.
He sought.
Yes, lordship. I prayed for.
You are appearing for the same.
I'm for the respondent number
No,
8.
no. Lordship, I am for the petitioner.
We thought you are filing an application on behalf of the petitioner. All right, Monday.
Grateful, lordship.
On Monday. Great.
Item number 12.
I appear for the petitioner. My lord, The petitioner, Lord, is an Amin. He retired from service on the 31st of July 2019.
Yes.
But he has not been paid any part or portion of his retirement dues.
No retirement dues.
No retirement dues. An issue cropped up with regard to non-approval of medical leaves availed by him. Beloved,
So they are treating it as unauthorized leave. You are claiming medical.
Yes. Now, beloved,
What is the period?
But the period is 1002 days.
1002
days.
All at once or intermittent?
No, but these are in tranches. Now, my competent authority, he sought instruction from higher authority.
Yes.
That is at page 97.
Yes.
Beloved, I waited for substantial period, and then, my lord, I went before the learned tribunal.
For what? Grant of retirement dues?
For grant of my retirement dues, number one. Number two, that I have not been granted any increment since 2001 in view of no fixation.
2001?
My lord.
You retired in 2001. Yes.
Because if, my lord, the pay fixation has not been done in view of this period of leave not been regularized.
Yes.
My third prayer was that since the pay is not fixed, hence the refixation under the revision of pay and allowances in 2009 and 2019 also has not been done. Three prayers. Increment, fixation of pay under the revision of pay and allowances, and disbursement of retirement benefits. In course of hearing of the application before the learned tribunal, an instruction was produced before the learned tribunal that the assistant secretary has opined that the competent authority can decide about the approval of this period.
So everything hinges on the absence.
Yes.
The moment the absence is dealt with, either regularized, whatever.
Yes.
Then everything will fall in place accordingly.
Right. Now, my lord.
So let us see what is the period of absence.
My lord, I come.
200 days.
No, that he has already said 1002 days.
Now, my lord.
1002, not 1002.
1002.
Yes, 1000.
Now, my lord, based on that, the learned tribunal, my lord, disposes of my application but granted only one prayer. Lord, with regard to disbursement of my retirement dues. Lord, the other two prayers, my lord, have not been expressed, my lord, to have been allowed. I came up before this honorable court. My lord, this honorable court, my lord, kindly sees, my lord, the last order, if my lord has seen, 10th September 2024, took note of the fact that in so far as the direction of the tribunal is concerned, that the competent authority would decide, that the competent authority would decide upon granting an opportunity of hearing, and that the competent authority has issued notice of hearing. But the coordinate bench will not adjourn the matter until after vacation, said that we await the result of the hearing. If the period is regularized, then everything will fall in place. But that is 10th September 2024. So today, my learned friend would apprise my lords as to what is the outcome of the hearing. But I have assisted to the extent that I could in the hearing, and
already you have been heard.
Yes.
How much time you will take for filing for passing an order on the
3 weeks time,
3 weeks. I've retired in 2019.
But a regularization of
when was the hearing done? You are now at least you are getting some retirement.
No. Lord, I address my lord on that part, my lord. Rules say that, my lord, the provisional pension, my lord, should be issued forthwith.
Yes.
Lord, I pressed for this prayer on the last occasion. But their lordship said that we are only about a month away from the next hearing because intervening vacations were there and the matter was posted immediately after vacation. Today, if my learned friend, my lord, is seeking another 3 weeks time, Then, my lord, I must say, my lord, that I should press what? I have to copy now. अच्छा. एक तो लाओ. WBS.
Is there any order denying the benefit? No.
My lord,
Till
Lord-
now, there is
nothing.
no order dealing with your claim by the authorities.
My lord, kindly come to page 97 first. My lord, then I press the rules.
No, first let us know, is there any order dealing with?
No. My lord, kindly come to page 97. Lord, this is 22nd March 2021. Subject is regarding prayer for provisional pension of so and so.
We are reading, just don't worry.
My lord.
So what, there was any order withholding the pay for?
No, nothing. Now,
Just, right,
Yes.
it takes note of a fact that last 11 months, the pay was held up.
yes.
So there must be some order of withholding
Nothing.
the.
They have not paid me. That is how they withheld. There is no express order to that effect. Now, my lord, kindly comes to page 129. This is 1st April 2024, which was produced in course of the hearing before the learned tribunal.
No, but the tribunal, this is before the tribunal.
This is before the learned tribunal. This is what was produced. The learned tribunal took note of this document and then passed the order, which is not annexed at page 131.
So actually, you are not aggrieved by that order. That order has not rejected your claim. That order has only said that they will take a decision.
No, my lord, I am aggrieved to the extent. Kindly seize, my lord, the order. Lord, the third paragraph starting with the words, the prayer in the application. The prayer in the application is for grant of release of all salary dues of the applicant since 2001 till 2019 with the benefits of ROPA 2009 and 2019.
What is wrong?
Now, this is the court, the learned tribunal takes note of my claim. And then while granting, from submissions and record, it appears that the opinion of the finance department was sought regarding regularization of 100,000 days. Memo number so and so presented by the department suggests that finance department has opined that the administrative department is competent to regularize such unauthorized actions as per rule. Accordingly, reference has been made to the ADM DLRO by the department to take suitable action. In view of the above, respondent number 4 is hereby directed to initiate process of regularization of unauthorized absence of applicant to the rules and take follow-up action leading to the release of pension and other pensionary benefits.
So we have said the tribunal has not rejected your claim. What wrong we have said?
Lord, I say, Lord, that the tribunal has taken note of my claim, but while directing, it has not directed anything more than releasing the pension. My other claims are not being heard also.
Everything is to be considered.
Lord, kindly see, Lord, that part, Lord, the directory part.
Hereby directed to initiate the process of regularization of 1002 days.
Yes.
Yes.
And
so, and will come after that. Obviously, everything is there.
Lord, kindly, may I read for my satisfaction? According to the rules and take follow-up action.
Follow-up. As a follow-up to give all the benefits. How are you saying only pension?
May I complete for my satisfaction? Follow-up action to release pension and other pensionary benefits.
Correct.
But the salary which is
that I knew that you will be saying that. It is not explicitly said. This is not denial. They say you regularize. Once they regularize, what will they do?
Lord, my increment part has not been dealt.
That will have to be, everything will have to be considered. That we can clarify the tribunal's order that they will consider
yes,
everything.
only that much, Lord.
Consider
that my increment, withheld salary, fixation
When
of,
they are considering, they have to consider everything, whether they grant or not, that is up to them.
when I pressed for this before the hearing authority, he said that I have been only asked about the regularization of the unauthorized leave. I shall only concentrate on that, nothing more.
How can you take such a stand?
On page 135 for a moment. The date of order is 28th of June 2024.
Yes.
And order passed by the learned tribunal 4th April 2024. This order 22nd June 2024 has not been challenged before the tribunal, or order passed thereon, or if any order, no order has been passed thereon. 4th April 2024 order was passed by the tribunal. Pursuant to the order of the tribunal, you was here asked for hearing.
So therefore, what have you done? You are still seeking time. Endless.
No, I want to produce that what was the result of the 4th July hearing or subsequent hearing. There are, what is the result? That can be placed before your honor, nothing more.
Which hearing?
No. On 28th July, page 135, yes, you are asked to appear in person.
See, what he is saying is that you are considering his regularization, you are considering his claim for pension.
Everything.
You will consider everything. You have whatever he is entitled to, you have to consider.
Yeah.
So that much we can clarify.
Yeah.
And give them some time to dispose of your matter.
Yes, my lord.
That
I'm
is what-
waiting for 5 years. I can wait for the time that my learned friend is saying. Let there be a clarification. Let them decide all the issues together and pass a recent order. Yeah.
Then we'll dispose of this
So
application.
kindly keep it pending, because my lord, for 5 long years, my lord, I'm waiting. This my lord is not going to come that soon, as my learned friend is saying.
Order is passed against him. He shall have a fresh cause of action.
Yes.
You will have a fresh cause. He's correct. You will have a fresh cause. How do you know what they will do today? You don't know.
My lord,
See,
Anticipate anything.
this 1002 days, they have already found that you have no leave to your credit. So if you have no leave to your credit for this 1002 days, most probably notionally they will just continue
This is
the
what my lord
service.
was said on 10th September when the matter was heard before the coordinate bench. My lord, 6 weeks have elapsed. My lord, my lord, only anxiety is that if this matter gets disposed of today, and my lord, an order is either not passed, I have to come in contempt, or an order is passed, I'm aggrieved, my lord, then again, my lord, I'll have to, my lord, again go before the tribunal. My client is languishing, my lord. For 6 long years, he is without any pensionary benefits. Let the provisional pension start. He should at least have, my lord, some source to sustain on. Look, kindly see rule.
10/9/24 order.
Yes.
That has already, we have already directed. Then you
No,
pass the
kindly
order.
see that. Kindly see that 28th June 2024.
You pass the order. We have already passed an order earlier. It is in the record.
My lord.
The-
Let him come with the order.
On 10/9.